Oh boy. So yeah, mistrial for the Karen Reed stuff. I mean, it's been what, over 2 months now since this case has started. I think this case started at the end of April. We're now in the beginning of July. I think the prosecution needs to be less confusing and concise. Listen, I think his presentation of the case was just all over the place. It felt very sloppy to me, and it kind of felt like even he wasn't sure what happened to John O'Keefe, and he was just trying to throw everything together and maybe see what sticks. It was kind of a last Friday, the jury gave a note. Was it Friday, right? I think it was Friday. Gave a note to the judge and was like, hey, we can't come to a unanimous decision. The judge is like, well, y'all need to deliberate a little bit more. This trial was over 9 weeks long. And I think, have some lunch, think about it, and see where you guys are at. And of course, she sends them back in. They eat their lunch. And she was like, hey, do you guys want to be sent home early today? The jury was like, oh, you know what? Let's stay another half an hour till, I think, was it like 4:15 or something? They stayed till 4:15 and then still nothing. So the judge sends them home. They have the weekend to not think about it. Don't think about it over the weekend. Over the weekend, enjoy your weekend. Wait until Monday to come back and talk to your fellow juror members and see where you guys are at. So Monday rolls around and it is today. And this is what happens. I woke up this morning and I was like, okay, let me go on Law and Crime. And right when I went to Law and Crime stream, the fan was like jittering a little bit. I was like, wait, there's movement in the courtroom. And I got in there just in time. Yeehaw, you here?
All right. So, jurors, I am in receipt of your note. Judge Cannoni, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind.
And I wonder, is it the foreperson that's writing these notes? Because these notes are really well written. Even from the first note that was sent to the judge, I think they covered their bases and they did a really good job at writing it out. I would have just been like, can't decide, no unanimous vote. Okay, we're done.
The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable.
Deeply held convictions. So it's not like they don't understand the evidence or what's been presented to them. Is that they each have deeply rooted convictions and they can't come to a vote. What happens now after a mistrial? Well, the state can decide whether or not they want to retry again. And they have announced that they are going to retry Karen Reed, which I'm really surprised they would announce it so soon. Unless maybe they know, because we don't know what the jury poll is. We don't know how many people thought maybe they were leaning not guilty, how many people thought they were leaning guilty, how many people weren't sure. We don't know what the numbers are. Maybe they know, and maybe based off of that, they're like, okay, well, let's move forward and let's do a retry again, because the DA, Michael Morrissey, announced that. And I wonder if Lolly agreed to it. I wonder if Lolly's like, yeah, let's do the retry. If Lolly's like, oh, fudge. Hi, Taxi.
We recognize the weight of this admission and the implications it holds. So, Mr. Foreman and members of the jury, I have an instruction for you. Our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict.
So this is the judge trying to give the jury a bit of a push, like, hey, are you guys sure you guys can't come to a unanimous decision? Are there some positions maybe you can rethink, as long as you're not just doing it just because you want to get the day over with, and you just want to move on to the holiday weekend, whatever. But are you sure there are some things you haven't considered yet? Like maybe you guys can really come to a unanimous verdict.
The result of his or her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are.
Really? I would be surprised if she would do that. Karen was going to take a plea before the FBI investigation. Where was that reported? I would be very surprised to hear that she'd be considering taking a plea.
Or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments.
Hey, Iris.
Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their own minds is a reasonable one. If it makes no impression upon the minds of the other jurors, who are equally honest and equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. I will now ask you, Mr. Foreman, and members of the jury to return to your deliberations with these instructions in mind. And as with my final instructions and the supplemental instructions I sent in, I will send in a copy of this charge as well. All right, so may that be marked, Madam Court Reporter, please. All right, so thank you. We'll send you folks back out to deliver.
All rise for the court, please. Jurors, follow me.
Oh man, poor victim's mom. She looks guilty. I mean, what does a guilty person look like? Greetings, Captain. Hello. Greetings. 9 weeks. Yeah. Very long time. So that was the judge giving the Tui Rodriguez charge to the jury. Now, I wanted to read this here. This is from the Suffolk County. I just drag this over here. Oh, no, I can't. No, it's a different browser. Give me 1 second. I wanted to read this page to you guys because I thought it was really interesting how the original Allen charge evolved. So failure to reach a verdict and the Tui charge. Can y'all see that? The requirement that the jury be unanimous in his verdict carries with it the chance that a verdict will not be reached. There's a tension between, on one hand, respect for the jury's role as a fact finder and a concomitant desire to avoid any coercion of a decision from a jury. And on the other hand, the desire to avoid expenditure of resources in trying a case twice. If after some time deliberation, the amount determined within the judge's discretion, the jury has not reached a verdict and seems deadlocked, the judge may instruct the jury with a dynamite or Tui charge. Under the original Tui charge, the jury was instructed in substance that the case should be decided and can as well by them as any other jury. So that's, the judge has reinforced this, I think twice already when she was talking to the jury, like, hey, like, you know, you guys are the best people to do this. Like, we've selected you guys can do it. You know, if we get anyone else on here, they're going to be tasked with doing the same thing. So you guys are just as good as anyone else. And so that kind of gives like a boost of morale probably for the jury, and that the minority should reconsider their positions in light of the positions of majority. So that's what the initial instructions used to be, that the minority should consider their position in light of the positions of the majority. They changed that though. So it's like not just like targeting the people in the minority and like pressuring them to change their mind. They changed it so it's like, okay, how about everyone consider the opposings, consider your opposing the oppositions and see if you can maybe change your mind. reevaluate the evidence, talk amongst yourself, blah, 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 blah. So I think that's a good change that they made. Instead of just be like, hey, minority people, we're looking at you, okay? Y'all need to change your fucking mind because we don't want a mistrial. I feel like once they go back to the jury room to deliberate, the minority people are just going to feel really pressured to just change their mind just cause. All right, so the charge was modified by Commonwealth v. Rodriguez. The primary change in the instruction is from a statement that the minority jurors should re-examine their position to a statement that the jurors, respectively, so everyone, all y'all need to reconsider your position, possibly, for acquittal or for conviction, should re-examine their positions in light of the position of those with opposite positions. The charge was also purged of an assertion that the case must be decided sometime. So before it used to be like, okay, y'all need to like, come on, hurry it up, let's do it. Time is ticking. But now it's like, okay, y'all, take your time. There's no time limit or anything. Take your time in deciding and see what you can come up with. Hi, Joseph. How are you doing today? Hi, Corgi. Hello. You don't think it's up to Lolly? You think his boss is the one making these decisions? I mean, I'm sure the DA made the decision. I don't know if he talked to Lolly or not, but I think Lolly can have a decision and say that like, hey, you know what? I don't want to do it. Get someone else to do it. I ain't doing it. Goodbye. So we'll see if Mr. Lolly is still going to be on it, if he still wants to do it, or if he's also on board, with Morrissey. Ooh, I lost where was I? They should re-examine. The charge was also purged of the assertion the case must be decided at some time. Okay, talk about that. Notwithstanding the modifications, the court noted that the charge has a sting, and our approval of it is not to be taken as an indication that it may be used prematurely or without evident cause. Stronger language clearly courts a reversal. With or without benefit of the Tui Rodriguez charge, the judge may determine that the jury is not going to reach a verdict and may declare a mistrial. Oh, mistrial. And discharge them. All right, let's go to the next portion of the day. So a couple hours passed. We're now in hour 26. Jury's been deliberating, and I think it's been about 3 hours since. Probably about 3 hours since.
Thank you. Be seated. Closing session.
22-117 Commonwealth versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in.
Straight to the point, Judge. Just straight to the point. Do you guys think the majority of the jury is probably voting guilty or not guilty? Based on how this letter is written, I will answer that. But that's me making assumptions based on how the letter is written. Hey, Aaron. I don't know if I said hi to you earlier, or maybe you just popped in. I mean, hey, if Lolly retries this, maybe he'll have a little bit more of an upbeat, Maybe he'll be a little bit more... Maybe he'll be different. We'll see. Jury's coming in. Oh, boy. You sure Karen's LA lawyer is thrilled about the possibility of returning to Massachusetts again?
Close the session. Please be seated.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse.
The family must really be devastated. His mom looked really devastated. She was crying, and I was watching a live stream somewhere else, and there were some people that were so mean to his mom. It was pretty fucking wild. They were like, "Oh, stop with the fake crying." It's like she's like upset because she doesn't know what happened to her son, or maybe she thinks she knows, and then she wants a verdict to go a certain way. But I mean, she just seems genuinely upset because she's gonna have to come back. If they retry it, right, she's going to have to come back, sit there, listen to all the testimonies all over again, and just basically just redo this. There's no conclusion at this point.
Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges.
Now, because it's written like that, some members believe that reasonable doubt was established. So I think they might be the minority. I mean, that's me like really looking into like the letter and the way it's written. Also, whoever's writing these letters, or maybe they're doing it collectively, these letters are amazing. They're doing such a good job with that. I think that the minority are the people that think that it is guilty beyond a reasonable doubt. And then maybe the majority are the ones that are, hey, we're not really quite sure. It seems to be lack of evidence. But let's listen to that again.
Passes the burden. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please.
So she's going to see them privately. I wonder if that's when, like, is she able to see them privately and be like, okay, y'all, so what's the poll on this? Like, how divided are we? And then was she able to pass it along to the attorneys? Because I want to know, why did the Commonwealth decide to say, hey, we're going to retry it? And like they announced it like ASAP. I thought they would wait a little bit. Moondog! Oh God, no, not that sound effect. Moondog, thank you so much for the 23 months. Oh gosh, I'm sorry, you two folks. I have some interesting sound effects on my Twitch thing. Moondog, thank you. I appreciate it. I hope you had a good weekend, and I hope everyone here had a good weekend. You're at an impasse with Lally. Reed can sue now as well. I just don't know how much resources she has, because if she wants this like a team of attorneys again, Yannetti, Jackson, I don't know if she just wants to get through the criminal proceedings and then, maybe focus on the civil stuff in the future. I think right now it'd be smart to just focus on the criminal. Like, let's focus on the big thing first, and then we'll go to the civil stuff in the future somehow.
Thank you. Be seated. Court still in session.
All right. I'd like to pick a status date to find out what our next move is. So I'd like to come back sometime maybe the end of July. I understand people have vacation schedules.
I'm going to forward through this a little bit.
Can we come in the week of the 21st?
That's fine.
Could we do the 22nd at 2 p.m. Ron?
I was trying to find out about the polling thing. From what I've researched so far, and it's been like very like, it says that judge has a discretion on whether or not they want to poll the jury. But a lot of the examples that I read was usually when there is a verdict, and then, the attorney can ask for a polling at the end. But it seems like it's at the judge's discretion if they want to or not. And I mean, honestly, if I was the judge, I could see why you wouldn't want to announce the poll, maybe. But if you were the attorneys, it would be very helpful to know, okay, so how many people were on the fence? How many people thought there was, guilty beyond a reasonable doubt? How many people were just like, no, the state didn't meet its burden at all? So, I mean, I think for the attorneys, it'd be great to know what the polling is. Just see, it's kind of like a rating of like how decently you did. But I mean, it could help for the future. But then again, like, you never know what batch of juries you're going to get in the future. So.
And I would hear from my client.
Is there another day that week? Could you do the 25th or 26th?
We'll get the poll from the jurors and the press. I don't know. I haven't heard anything about that, but maybe.
Unfortunately, I think I'm supposed to be on vacation on the 25th.
Okay, the 22nd and the 24th are not great dates. So.
What about the 19th and 9th? Is that whole week?
No, that week's not good. Teaching that I cannot get out of.
Can we do August 7th, 9th? Any of those days?
No, we'll do the 20th.
Yeah, she's like shaking her head. I mean, it looks genuine to me. I mean, it makes sense why she would be reasonably like genuinely like upset about this. Imagine you're like family members, and then if there's gonna be a new trial, like literally you have to come back and sit there all over again, unless you don't want to. But I feel like you probably would, right?
22nd. We'll go back to the 22nd at 2. I can't let it go that long.
Your Honor, so for those, Mr. Little and I are not available on the 22nd. We have here in Los Angeles on the 22nd.
Okay.
We're proposing to appear remotely anyway.
Okay.
But for a status conference, I don't want the court to think it's disrespectful to the court, but Mr. Little and I probably will not.
Okay. So you and your client will be here in person, Mr. Yannetti.
Sure.
All right. All right. Thank you. We'll see you then.
All rise.
So Yannetti, Karen Reed will be there in person. Here, I guess I'll slow it back down. And then Mr. Jackson and... Is her name Elizabeth? Elizabeth Little? We'll just conference in. And then after this, I want to read the brief statement by the Commonwealth, and then we'll listen to the little mini press conference that Jackson and Yannetti gave outside of the courtroom. I don't know if Karen spoke. I don't think she did. I think it was just the attorneys. Are they allowed to talk about what happened in the jury's deliberation? Unless there's a gag order, yeah, they can talk about it. They can be interviewed. I don't know if they want to. That's a lot of attention. But I would love to hear what was going on in the deliberation room. I would definitely be refreshing my YouTube feed to see if any of the jurors decide to speak out about this, because I'm so curious. Yeah, I mean, a lot of us want to know what's going on with the federal investigation. Or if we won't get any information at all. We'll see. Okay, so I think that's it for this feed. And then let me go over to X, Anjanette Levy. Mistrial has been declared in the matter of Commonwealth v. Karen Reed. Judge Beverly Cannoni set a status conference date of July 22nd, 2024 at 2 p.m. This is their statement. First, we want to thank the O'Keefe family for their commitment and dedication to this long process. They maintain sight of the true core of the case to find justice for John O'Keefe. The Commonwealth intends to retry this case. And I'm like thinking, I want to hear this coming out of Lolly. Like, is Michael Morrissey and Lolly, are they on the same boat about this? Like, is Lolly's like, hell yeah, let's do this. I'm going to be gung-ho. Like, I'm going to do much better. Or... I just want to know where I don't know. Maybe Lolly's going to be like, no, I don't want to do this. You do this or get someone else to do it. Is my voice cutting out or is it my connection? Oh, no. You're the only one who's brought it up so far, but it sounds fine. Okay, thank God. I'm like, oh, please, no audio connection issues, please. I did tweak my audio a little bit so you guys don't hear me breathing as much, but it's like a smidge of a, yeah. I have to go back and redo my audio, I think. When I was editing my video, I was like, damn, you could really hear me breathing, and I don't want you guys to hear me breathing like that. Okay, so they're gonna retry the case. From what I've heard, if they want to retry the case, they have a year to retry the case. Now, if Karen Reed somehow, if she can't do it within a year, like if it's on her end, then maybe it can go, maybe more than a year before her case is retried. But from what I've heard, the state, if they want to move forward, they have to retry the case within the year. So we don't know if it's going to be in a couple of months, less than a year. We'll see. We'll see where it's at. We'll have to, listen to this conference date, July 22nd, 2024. I just want to hear from Mr. Lawley, honestly. I want to see what I want to hear what Mr. Lawley is going to say. The state has nothing though. I don't know what Lawley can do. There's a lot of things that Lawley can do to improve, but I don't think there is anything Lawley can do to get to beyond a reasonable doubt, in my opinion. Like, I think he can present the case better. I think he can reorganize the witness list a little bit better and maybe not be so repetitive on certain, questions. And, like, we don't need repetitive testimony, right? About who was playing the game that night, the basketball game, or the snow stuff. Like, there's a lot of things that were just felt too repetitive to me, where it's like, I feel like we don't need to do this, right? Or like some of the educational background, or some of the, I think that happened a lot in the, with the paramedics and stuff in their credentials. But I don't think that Lawley can do anything different unless he just gets like a new set of experts. I don't know. because at the end of the day, you still have the medical examiner who says this. You still have the medical examiner refer to the woman who focused on neurology. I think that's what it's, yeah, neurology, right? Where she examined the victim's like brain. And, you know, we didn't really get, we got information out of it, but not like, oh, okay, he was hit by a car and this is what happened, XYZ and stuff like that, right? I don't know. I just don't know what Lolly could do better. Lolly could maybe replace Trooper Paul, could be a huge one. Like, okay, well, instead of having Trooper Paul be the sole person to testify about the crash reconstruction, maybe get another expert in. But then again, you know, we had the experts that testified for the defense and they did really good on the stand. They did really well. I don't know what Lolly can do differently, but I mean, if they play the trial, I'm definitely going to watch it. And imagine if we already thought Lolly was repetitive with it during the first 9 weeks, imagine imagine Lolly redoing the case all over again and then with the same witnesses. Like, I think our patience will be very, 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 very thin, you know? But who knows? Maybe he'll do better. Maybe, you know, he'll go back, watch how he did, and then he'll make some major adjustments. And then lastly, I want to hop onto, let's see, where was they did like a little mini press conference. Is it this one? Oh, here it is. Boston 10.
Throughout this trial, and of course we heard them briefly on the steps of the courthouse afterward, do you think internally, in their private moments, they are considering this a victory for their side?
Oh, absolutely. It's a victory for the defense to do the information for them. So they have the option charges.
To listen, the defense attorney also did. We want.
Folks, this is what it looks like when you bring false charges against an innocent person. The Commonwealth did their worst. They brought the weight of the state based on spurious charges, based on compromised investigation and investigators and compromised witnesses. This is what it looks like. And guess what? They failed. They failed miserably, and they'll continue to fail. No matter how long it takes, no matter how long they keep trying, we will not stop fighting.
I agree. Lolly only has rotted material to work with. There's no way around it. He can sprinkle 18-karat gold all over this. Won't change anything about that stank, though. He's always going to have a problem with Proctor. Yep. Medical examiner, technical experts, Trooper Paul. The inconsistent statements of the McCabe's. I can't substitute Paul because he was there. Paul who? Everything Proctor or Higgins touched should be considered fruit of the poisonous tree. Yeah, I mean, there's just too much. I know that we were giving Lolly shit, but at the same time, Lolly didn't have, in my opinion, Lolly had a lot of crap that he had to overcome. And a lot of it was probably difficult for the jury to overlook when they were deliberating. Hey, Kyra, how are you doing today? Mistrial.
We have no quit.
Alan, you're going to stay on?
Go ahead. Will not stop fighting. We have no quit.
Alan, you're going to stay on?
Go ahead.
Oh, you heard that? Someone shouted, Alan, are you going to stay on? That's what I would. I mean, I'm sure, you know, they did a good job, I guess. And she probably wants the same team. Get Alan, get Jackson up there. I don't know if she's going to.
I just have two things to say, folks. Number one, I am in awe of the strength and courage of this remarkable client that I've had the privilege of representing since day one. And number two, I want to send a message to all of her supporters out there. Your support was invaluable. We are touched, and we ask for your continued support. I'm not from Texas.
Oi, Alan, are you fucking going to stay on? I'm doing all right. How are you? I'm doing okay. I redid my garden because I told you guys I was planting my flowers. I went to Vegas for about 2 days. I came back. Everything was like in flames. Okay. I'm being very hyperbolic, but I came back and everything was crispy and I was like, no. So yesterday I replanted some of the flowers and then I built this shade tent for them. Now, if it rains or if it's windy, the whole thing is going to just fall over because it's the worst. It's just horrible, but it's working for now. I'll put pictures in my Discord.
All of her supporters out there. Your support was invaluable. We are touched, and we ask for your continued support. I'm not from Texas, like my colleague here. I'm a Boston kid, but I'll repeat what he said, which is, we ain't got no quit.
That was the defense team outside of court right after the mistrial. We want to go now back to Michael Coyne, dean at the Massachusetts School of
Jackson Giannetti, yes, if she can afford them, they're expensive. I heard rumblings about potentially there might be a doc made out of this, and that would make sense. So it might be to them worth it to want to stay on this case for the future, you know, in case, I don't know, that could be a way to like get more recognition to your law firm, fame, whatever. So, you know, maybe they'll decide to continue to stay on. I don't know. Maybe like at like a reduced rate, or maybe, you know, there is enough money to pay them. But it's crazy. I just can't imagine if I was someone and there was a mistrial and then it's like, shit, you got to pay for the attorney fees all over again. Like, like how does that work? I wonder how much that is.
of Law and our legal expert. Michael, one of the questions I wanted to...
I think that was it. Yeah, that was it. I don't think there was any other...
A Boston police officer for 16 years, 46 years old. And at this point, there has been no accountability for his death.
2.5 years since his death. It was January 29th, 2022, and here we are on July 1st, 2024, and they will have to retrial if they decide to retry this case within a year. And your questions will be, will it be as long? Michael Coyne, our legal expert, just said it is unusual to have this lengthy a case. It was 9 weeks. There were over 600 pieces of evidence. There were 74 witnesses. And
I wonder if Lolly's going to trim down the witness list this time.
That is a tremendous amount of information for that 12 jurors to take in. And despite that, they said those 12 jurors, when they went to the judge, said it wasn't the law that they were having a problem with. It was the convictions of the two sides who would not budge on what they believed to be reasonable doubt and whether or not the prosecution had reached that burden. And that's why you see right there, you can see... oh,
hey, Debbie, how are you doing today? Her parents are giving loans, etc. Yeah, I can see that too.
Karen Reed hugging her mother and father and remembering that the John O'Keefe family, the O'Keefes who have sat there also every day during the 29 days of testimony, during the 9 weeks they have.
Okay, that's it from there. But I don't know. Let's see if the jury is going to talk. There was like a footage that I saw of there were police around the courtroom trying to make sure the jury can leave safely and people won't be able to like figure out who they are. But I'm like, how do you organize that? How do you, I don't know. That seems like so hard to organize, especially with like a lot of people around in the courtroom. There's like cameras and stuff. How do you make sure they leave without people figuring out like, oh my God, wait, that was a jury? I don't know. Hi, lady. How are you doing today? How's it going? How's it going? I wouldn't. I would just pile it on and could only get 2 mistrials. The question is, the state can do anything before it becomes double jeopardy. Some of the witnesses will have legal issues themselves after this. Maybe. Get out the sheets. I was wondering, the sheets to hide the jury in. Well, I mean, they have to drive back home.